Thank you very much indeed. Amnesty International welcomes the opportunity to present today on this question. Our thanks then to the Convention Secretariat, but more importantly, thanks to you, the delegates of the Convention, for selecting this issue for consideration. ESC rights, as we've already heard, are within our political tradition. In 1937, the framers of our Constitution put some of these rights in Bunreacht na hÉireann before they were set out in the Universal Declaration of Human Rights. And 3 decades later, these rights became binding in international human rights law. And it's important in that regard to recognise that these aren't alien concepts to states. When we talk about international human rights law, states, including Ireland, wrote this law. So when Amnesty International calls on states to respect international human rights law, we're asking states and then governments from those states to simply respect the laws that they themselves wrote. The experts have outlined this morning existing Irish protection for ESC rights. Our Constitution can provide for these rights. There has simply never been sufficient political will to protect the range of rights we are committed to under international law. What we're advocating then is neither radical nor revolutionary. We are in a moment of change, I think it's fair to say, as a country. We're emerging from some of our darkest economic days, whilst also looking towards the centenary of the birth of our republic. We must then consider how we might do things differently, how we ensure that our country serves all its people and makes decisions in our collective interest. In 1996, the All-Party Constitutional Review Group identified that the list of rights protected in the Constitution was incomplete. At that time, they considered that ESC rights were not in need of further constitutional protection. This was almost 2 decades ago. This position is fundamentally outdated. So let me then deal with some of the outdated myths about ESC rights. Well, as I said earlier, these rights were negotiated by states, including Ireland, to be enforceable and not simply aspirational. Moreover, ESC rights can be enforced and are enforced elsewhere today. The rights contained in the International Covenant that Dr. Thornton referred to earlier have been given meaning by UN bodies and other international rights mechanisms. These rights are also enforced by courts around the world, in countries like Portugal and India, South Africa and Argentina and Germany, all enforcing and interpreting these rights in their own national contexts. As outlined by the experts this morning and a few moments ago, Irish courts have enforced the existing limited ESC rights in our constitutions. So therefore, Irish courts could determine the meaning of rights like health, housing and social security in an Irish context. One big myth, and we've dealt quite a bit with this already today, or you've dealt quite a bit with this in your discussions already today, is that putting further ESC rights in the Constitution would place policy making in the hands of the judiciary instead of the government. Well, experience tells us that that simply isn't the case. Firstly, putting these rights into the Constitution would first and foremost require planning by government, making recourse to the courts a last rather than a first resort. And even when Irish courts have enforced existing provision, they have been very, very reluctant to prescribe policy. In education cases, for example, they've given the state a great deal of room to decide how to implement law and policy. They have instead identified broadly what had to be achieved. And only where the state failed to take action did the court take a stronger role in ordering the state to do something specific. This stepping in by the court has been criticised. But isn't that right? That courts will tell the state when it's not meeting its constitutional obligations as decided by the people of the state. And that where it fails to take steps to meet these obligations, the courts will, in exceptional circumstances, direct what the state should do, in exceptional circumstances. And delivering on ESC rights will not bankrupt the state. The International Covenant recognises that governments have limited resources. These rights have to be delivered progressively, so over time, using available resources and providing for, at the very least, a minimum core level of those rights. Ireland already spends considerable sums in areas like health and housing and social security. Constitutional provision would mean that decisions about how that money is spent would have to take into consideration the state's obligations to deliver on rights like health and social protection. Surely we must link what we spend with what we hope to achieve by spending in the first instance. We commissioned public polling by Red Sea earlier this month. 81% of people polled supported decision-making and expenditure based on human rights. As the economy recovers, we must consider how the fruits of that recovery are spent. The Constitution should be amended to give protection to the economic, social and cultural rights which Ireland has agreed to be bound under by international law. Aoife Nolan has identified, and you've already discussed, some of the different forms that constitutional protection could take. But what would it mean in practice? Well, human rights law is outcomes focused. Government decisions and expenditure must be geared toward those outcomes. Outcomes agreed by states, including Ireland. For example, that everyone should be able to access healthcare when they need it, that people should have an adequate standard of living for themselves and their families. The how, though, is up to government. For example, human rights law does not prescribe public health provision over private, only that all are able to access essential healthcare when needed. And we can expand upon that further in the panel discussion later if we need to. We need to fill the gaps in our existing system. We've already heard reference to how Ireland reports to the UN bodies and other bodies on how it's delivering on these rights. And those bodies report back to Ireland on where the gaps are. So government already knows what needs to be done. These are not unknown quantities. We also need better processes, I think most people would acknowledge, for planning and decision making. Accountability has become the byword in recent years for the promise to do things differently, to make better decisions and deliver better outcomes. And if we look at how the courts have protected ESC rights in other countries like Latvia and Germany, we see a focus on good process. So the questions that the courts have considered are, have decisions been made in a transparent manner using reliable evidence? Good process, transparent decisions using reliable evidence. Constitutional ESC rights would link economic policy and social policy. Human rights require that social policy is based on human rights outcomes and that economic policy is directed to growth, creating the resources to deliver on those human rights. If we really value these rights, if we wish to protect them in the long term, for this generation and the next, then we must make them sustainable. Some will argue, and this has already come up as a question for you as a convention, that these rights don't need to be placed in a constitution, but could be placed in legislation. Well, they could. But the simple truth is, no Irish government has done so or indicated any intention of doing so. And any such legislation could, of course, be reversed by future governments. Only by redressing the imbalance of rights in our Constitution can we ensure that rights are sustained in the longer term. So exploding the myths about ESC rights shows that we can give them greater constitutional protection. It would also improve public administration and governance in our republic. So why would we not? Well, greatest opposition appears to come from within a largely dysfunctional system and those who would see their role as directing that system. Perhaps, despite all the evidence to the contrary, they wish to maintain the status quo in the hope that flawed and political administrative systems will deliver. But support comes from civil society and frontline organisations and from the Irish people. 71% of those we polled believe that the Constitution should be amended to protect additional rights. It is for the Irish people to decide what human rights governments should be obliged to protect under our Constitution. So for this convention to recommend that such a question be put to the people would be a profoundly democratic act. Those who framed our Constitution 77 years ago had a vision for our republic. Further enshrining ESC rights would help give effect to that vision. It would, of course, not cure all of our ills, but it will require that government design systems that prioritise good, evidence-based decisions in the interests of all of our people. And who could object to that? So the fundamental question for your consideration is, should the Constitution be amended to include greater protection of economic, social and cultural rights? And we propose that it should. Thank you.
Okay. Thank you very much. And now Mary Murphy, representing the Irish Human Rights Commission.
Thank you. And like Colm, I'm absolutely delighted to be here, and thank you for inviting us. And thank you as well for deciding to deliberate on this really, really important issue today. I speak to you today as the acting chair, temporary, of the new Irish Human Rights and Equality Commission designate. And we had made various submissions in 2005 on this issue, and when we heard the Constitutional Convention was being established, we wrote in 2011 outlining and setting the agenda for this. So we're absolutely delighted to be here today and that it's there. And we would argue that a large number of rights, and particularly economic and social rights, are absent from the text of the Constitution or from the remit of constitutional recognition and protection. And we'd like to see the totality of those human rights guaranteed domestically in the Constitution. And as people have said, it's a Constitution that of its time was very progressive. It was established 11 years before the 1948 Declaration on Human Rights. So it was very, very progressive for its time. And it did establish a culture of fundamental principles, as well as named rights in the area of education. So it was clearly thinking of the common good and the idea of a just society. 77 years on, it's wonderful that it's still a living document and that we have the power to amend it. And it's entirely consistent with those original humanitarian principles in it to express them now in contemporary terms as justicable economic and social rights. And I suppose through our work in the Irish Human Rights Commission and in the Equality Authority, we see on a daily basis the experience of the public and the frustration of the public as they do try to vindicate what they perceive to be their economic and social rights. They're often very, very surprised to find how absent those rights are. So consistent with Amnesty's findings there, we'd see a clear gap between what the citizens think they have and what they want to have and what's actually there for them in relation to domestic mechanisms to vindicate their rights. And just to add, I mean, in my own working life over the past 30 years, I've worked with various organisations in the areas of unemployment, poverty, gender equality and housing. And I've seen firsthand the powerlessness of Irish citizens as they struggle to articulate the need for these rights. And I'd say to people who have a fear of a culture entitlement growing with the realisation of putting some economic and social rights into our constitution, not to be so fearful of that. I really do think that the powerlessness that our citizens actually experience at the behest of trying to realise very, very basic rights, like simply accessing a social welfare payment, is quite far away from a culture entitlement. And I think also the fear of giving too much power to judges, I think it's a very real fear and it does need to be unpacked and explored, and it's great that it is being here. But my sense is that putting economic and social rights into a constitution wouldn't interfere with the separation of powers. In fact, it could be argued that if you name rights in the constitution, in fact, you limit the power of judges to be active in naming them themselves. If the people name them, then the rights are put there by the people. And in that sense, it can actually reinforce the separation of power. And I think that's clear in theory and in practice in courts right around the world, and particularly in the European tradition of economic and social rights, where the role of courts hasn't been to determine policy or resource allocation. Rather, the courts determine if government decisions are reasonable, proportional and consistent with due process as set out in human rights principles, if they're accountable, transparent, evidence-based, consultative, participate, and if there's been adequate consideration of alternatives. And that's what people mean by a framework for good governance for government. There are fears about can we afford it, and it does raise issues around resources, and they've been voiced here today. But there is the caveat of it being subject to maximum available resources. And be it in the field of health or education and social security, just because you can demonstrate a need for something does not mean that the right is afforded that you have to get it. What it means is that governments, provided they can explain why after a decision-making process that was reasoned, proportional, non-discriminatory, that they can't afford to give that need or that social support to somebody, then the human rights principles are still respected. And that's crucial, because economic and social rights aren't a floodgate or a panacea. And to propose them isn't particularly radical. They do not ignore resource limitations. They give governments a framework in which to manage the limited resources that they have. And that's absolutely important, particularly when it comes to protecting the most vulnerable. And the international experience does show that courts are even-handed and balanced in how they've actually used their powers in that respect. And I think it's really worth reflecting on this in the context of the crisis. First of all, because it reminds us that we're all vulnerable, and these rights are for everybody. They're not only for the most vulnerable. We could all need these, and so could all our families, our kins, and our networks. They're an expression, actually, of our empathy towards each other, and I think that's very important. But I do think, and in the Irish case it's worth considering, that had we had a stronger judicial framework of economic and social rights, we might have had greater buffers or shock absorbers in the context of managing the fiscal adjustment we've had to do in the context of the crisis. And the Council of Europe is very clear that human rights are not dispensable, even in times of acute crisis. Now, don't get me wrong, I'm not saying that had we had rights in the Constitution that we wouldn't have had the scale of cutbacks that we had. Of course we would have had cutbacks and severe cutbacks, but they would have offered a fair framework and a transparent and accountable framework in which citizens could understand how decisions were made about what was cut. And that's really important in enabling citizens to keep confidence in and faith and trust in governments when there's crisis in a country. And I think that framework for governance is absolutely crucial, and we're missing it right now and over the last few years. And let me just give you two practical examples of what that means in practice in countries where they do have justiciable rights in the framework and they could use it during the crisis. Colm already mentioned two, Latvia and Germany, and actually they're the two I want to look at as well. In Latvia, early in the crisis, there was an attempt made to very substantially reduce old age pensions. It was taken to the Constitutional Court of Latvia, and the court made three very important rulings. They argued that the Latvian government had not given full and adequate consideration to the whole issue, that they hadn't given an adequate transition period for the citizens in order to cope with the impact of the cut that was coming, and that they hadn't given citizens effective remedies in terms of being able to challenge these types of decisions. But crucially, they also said, the Constitutional Court of Latvia, that conditions posed by international lending bodies like the IMF could not be used to thwart their own constitution. So the Constitutional Court actually gave power to the Latvian government to go back to the international lending bodies and show how they had rights in their constitution that had to be respected. And they managed to negotiate a different outcome. The pensions were still cut, but they were not cut to the degree that they would have been cut without the protection of the Constitution. And that's very, very reasonable and practical.
1 minute.
Okay. 1 minute. Italy and Portugal, similar kind of processes occurred. Germany, a social security cut that again the courts considered and found the cut eroded the basic dignity of the German citizen and crossed a fine line and wasn't considered reasonable or proportionate given the government's consideration and economic resources, and the government was told to reconsider it again. So these are very real. It's the government who's making all the decisions here. The court are adjudicating whether those decisions are reasonable and are protecting the interests of the citizen, and particularly the most vulnerable citizen. And I think those examples show that there's plenty of safeguards against the grounded fears people have about could this be too much power to the courts. What the courts are doing is very specific here, and what the role of the government is also very specific. So I do think that the economic and social rights being justiciable, it gives power to the citizen, first of all. It also gives power to society to work with citizens. It gives the kind of tools that Aoife was talking about that can help us try and create that greater, more equal and diverse society. And people have already said that's good for competition, it's good for economic growth, it's good for everybody to have these basic foundations of human dignity and civilization in our constitution. So in terms of a concluding remark, I'd say that it's very timely here. I think the crisis has been a great moment for us to reflect on where we were as a society, as an economy, And we know that we need to do things to rebalance the kind of country that we have. I think that justiciable rights gives us a really serious opportunity to rebalance power in Ireland, to make our processes better, our government processes better, and to give some checks and balances for the people so that if governments are acting unreasonably or disproportionately in the allocation of resources, citizens have a recourse to a domestic mechanism, not to international courts, but to a domestic mechanism, and that we can stop the increasing tendency of Irish citizens of having to use international mechanisms. We should be able to do this at home. Thank you.